Good afternoon, everybody. I can see that people are beginning to join us, which is great. So I think we'll make a start because we're just a few minutes past 3. Would fellow panelists like to turn on their cameras, please? So everybody can see each other. That's wonderful. Thank you very much. It's really good to be with you again this afternoon to talk about mediation and arbitration. Hopefully, by the end of our hour, we will understand the difference between M and A. And basically with mediation, with the backlog in the courts, mediation is a good solution as it saves time, is cost effective, and not only saves time, but does bring closure to, worrying issues and time consuming issues. Now, we're really pleased that Nick Woolf is with us. He's actually in New York this afternoon, so we're really pleased that he's able to join us. So Nick Woolf of Swan Turton is going to talk about the importance of the court side enforced, encouraged ADR, which is alternative dispute resolution, general mediation and the process and comparative cost. Nick, over to you.
Sorry, I was trying to unmute. Good morning, everyone. If you're on my side of the pond, good afternoon to you. My name is Nicholas Woolf. I'm a solicitor and I practice mostly litigation. I've been doing it for over 40 years. So one would ask now, why would one want to get involved in ADR? Well, first, what is ADR? ADR means alternative dispute resolution, which means trying to settle a dispute by not going to court. Why wouldn't you want to go to court? Well, the courts are very expensive. Even court fees now are very expensive. Lawyers are very expensive, and they are clogged up, and the time it takes to bring a dispute to a conclusion can in some cases take years. So one would want to avoid that. Also, one has to realise that when you're going to court, you're going to get a fair process. But there will be a third party making a decision at the end of the day, which probably means, unless you settle in the meantime, that the decision is out of your hands and the risks are very high. If you enter into alternative dispute resolution and you manage to reach, in a number of ways, some sort of agreement, it means you do have some control. Whereas once you're in court, you may think you've got a terribly strong case and all the evidence is on your side, but a judge may pick up on something or have dare I say, a particular prejudice, and it may not go in your favour, and you can land up not only losing but paying the other side's costs as well, which can be very expensive. So that is a very good reason for entering into ADR. Sorry, I've got a number of notes here, which are all on the screen. So there are lots of different types of ADR, and some of them, there are. It's not all, it's not always a good thing. There are drawbacks, because if you don't manage to settle something through ADR, it may delay the time and increase the cost. You may be exposing your case to the other side, which you might not want to do, although you're probably going to do it and do it during the court process, and there may possibly be some unenforceable outcomes, and it may not be suitable for some disputes. I mean, some people just don't want to settle, and also then, of course, there are other more technical issues like limitation issues, which need to be taken into account. So what are the different types of ADR? Well, the first stop is always negotiation, which just means either you or your lawyer negotiating with the other side and hopefully coming to an enforceable agreement. That can be very cost effective, and is probably a very sensible way to start off. Then, of course, there's mediation, and I stand to be corrected. What does mediation mean? It means you have a third party, an independent party, come between the two parties and that third party's object is to try and engineer an agreement between the parties, so an agreement settles. We've got mediators on the panel, so I'm not going to talk about the actual process within the mediation, because they do vary, but usually there are position statements and people make statements. And in my experience, I've had some good experience and some bad experience of the mediation, but I don't think I've been to any mediation where I've had an offer before 5 o'clock. Then there's mixed mediation and arbitration. So where you mediate and if there are issues at the end of the mediation which haven't been agreed or haven't been settled, the mediator can then become an arbitrator. This is a relatively new animal, and that can come binding. Then there are things like the conciliation service for example, the most well-known conciliation service is ACAS, who try to engineer agreements between parties. Then there's something called early neutral evaluation, which is it's an old-fashioned idea which has been modernized. The old-fashioned idea is that the parties agree to get counsel's opinion, and they will follow that. So it's a bit like getting an expert in, but you have an evaluator. Then you can have adjudication, which is a bit like a private court, which is like family courts now. You can have private hearings, and you then go and get hopefully an agreed order once that private hearing's been heard. And there are a number of former family judges doing that. You can have a dispute review board, which is often or more commonly used in public companies, or you can have arbitration. And arbitration is more like a private court system. But the great benefit of most of these outside court processes is there's a degree of privacy to them. Courts are open, courts are public. If you want to wash your dirty linen in public, well, so be it. It's quite difficult now to have a court hearing where it's not public. Courts are beginning to go on television. I watched a Supreme Court case last week. I was in bed with COVID. I could watch the whole thing from beginning to end. So that is a very general overview of the ADR landscape. Now, in terms of what the courts encourage ADR hugely, my view is that the courts don't actually have the power to enforce mediation. I mean, there is some debate about this, but judges, certainly in the higher courts, will encourage at every stage parties to go and mediate and go off and settle matters, and they will make it difficult for them. So if you have and there are a number of mechanical things that work in favour of the courts promoting mediation. So if it's a small claim, then as part of the directions process, you're asked if you want a break to mediate for a month or negotiate for a month. As part of what's called the pre-action protocol, which is before you go to court for a certain process you must go through. A number of the pre-action protocols encourage mediation, and some of them it's sort of compulsory with regard to engineering and building disputes. And once you get to court, there is such an overload and such a shortage of judges. Judges will do everything they can to encourage the parties to mediate and settle the matter. So I've probably done my time, I think. Is it 10 to 15 minutes each? Is that right, Sally? You're on mute. Okay. Well, thank you.
Trying to find my mouse.
Thank you very much. Are there any questions? Because sadly I'm going to have to disappear early. I've got something else on which is rather pressing.
Okay. Do you remember last time you spoke to us about this, Nick? You did sort of say, is this still the case? If you're offered mediation and you refuse it, and you go
yes,
and you
you're
win,
quite right.
the court can refuse you your costs. Yeah,
that's right. If you are offered, it's very thank you for reminding me. It's a very important point. If you are offered mediation in the course of litigation and you refuse it, then there are a number of cases to show that at the end of the hearing, because you refused mediation, you may be liable not only to pay your own costs but the other side's costs. So refusing mediation can be a very dangerous thing to do. You're better maybe off going to the mediation and just saying nothing.
Right. So mediation really is what the courts want. I mean, yeah, it is the way forward.
Yes, it's promoted, and the master of the rolls, Voss, is, I think, they're talking about bringing in some new rules to try and make it compulsory.
Lovely. Thank you very much indeed. Thank you. And
that's a pleasure.
I'm sorry, Dr. Raj, do you want to say something?
I have a question for Nick, because good afternoon, Nick, and good morning to you in US. Basically, as you were discussing about the mediation and the court procedure till now, arbitration also, what is the status of mediation in US court?
That is a very good question to which I don't know the answer. And when you say the US courts, of course, the courts vary from state to state. I know that they have been encouraging ADR much earlier than we have, because when I was here in 1980 for the first time, I went to I think it was the Washington Bar Association, and there was it was all new mediation then, and they certainly encourage it. But it's a far more litigious society here. People like their day in court.
Yeah, I was there in June for the mediation conference, and I was one of the speakers, and I had met so many attorney general and solicitors over there. So still mediation is not full-fledged into the court procedures, and they are still waiting for the bill to come out, and like private mediation centers and the walk-in mediation center is still in wait. Thank you. Thank you.
Lovely. Thank you very much indeed, Nick. We'll let you jump off to your next meeting. Thank you
very much.
Yeah, thank you.
Good luck today, Nick. Thanks very much for all your help today and presentation.
Bye.
Thank you.
Bye.
Our next speaker is Dr. Renu Raj of Radanks, and you're going to be talking a little bit about the difference between M&A and also about mediation, a boon for dispute resolution globally. The floor is yours.
Thank you. Good afternoon, all of you. I will be first defining that what is exactly the arbitration, and then I will tell you that what is the difference between the arbitration and mediation. So the arbitration is also alternate dispute resolution. It is not in the general court. It is a private court procedures. In that you need lawyer, judge, and the two parties. The parties are just passing their information, and whatever decision they want, that will go through the arbitrator, not directly from the parties. So anyhow, at the end of the day, the decision is made by the judge and the arbitrator, not by the parties what they want, what agreement they want. So this is the arbitration. Arbitration is a part of litigation, where the mediation is nowhere part of litigation. Litigation is all the court procedures. And arbitration is also, like in that also the confidentialities are there, but it is written process. All the case has been written in the paper. It should be in writing. And all the papers, all the cases, all the things should be in written, given by the parties to the arbitrators. And then the case starts. So arbitration is also a form of litigation. This is very important to understand that arbitration is also part of the litigation. It's not a mediation. Now we will come to the mediation. Arbitration can be like done for the state matters also, individual matters also, but the most important thing to understand that arbitration is a part of litigation where people, many of us, we are always getting confused between the arbitration and the mediation. For arbitration, arbitrators are more knowledgeable to the particular case subject. That's the reason they are sent to the private courtroom to discuss the matter, not with the general solicitors. So now we have come to the mediation. Mediation is unlike arbitration. It is less formal process, and mediation is done by very confidentiality and neutral. No written statements are there, no written case histories are there, and the decision is made by the parties. A and B have got dispute. They have to come to the point what exactly they want with their own conversation. They don't need anyone to pass their want, pass their willingness to the arbitrator or to the solicitor or to the court judge. And then the judge will decide that this is my decision, arbitrator's decision, and the lawyer's decision, and you have to follow. So in mediation, you don't have to follow all that. Mediation is all what the client they want to do, what the client want to settle on the dispute. So mediation is a very simple process. It's a very, very short period process, 3 to 6 hours. Any mediations can be sorted out. And this mediation is, the mediators are nowhere known the case much before. It is usually mediators, they come to know the case within 24 hours only, and mediators are not contacted by mediators are not contacted by the clients directly. So they can't be, mediators cannot be biased or one-sided decision maker. So mediation is one of the very much in demand right now, and it is very much helpful for the world. Cross-border mediations are also very good. It is coming up slowly. We all are coming up that. So advantage of arbitration is a bit good for the clients that they get the private courtroom confidentiality process. Like in general court, many people are there and they know that what is your case, and everyone will understand that what judge has asked you, what lawyer has discussed. But in arbitration, you are in a private court, only your arbitrator and judge and you yourself and the other party is there. So that case discussion will not go out. So you are in the little confidential process. And in arbitration, binding and enforceable awards are there. Like you have to be binded by the court's decision. You have to take that award, whatever the arbitration, whatever the decision court has made. Faster than traditional litigation. In private courtroom, you are only, there is no dates, things and all. So it is faster. Attractive for multi-jurisdictions disputes, where you can go for the private courtroom for the arbitration. Disadvantage of the arbitration is different cost structure. Everywhere different cost structure. It's a very expensive process, lack of precedents. And advantage of the mediation is, apart from the arbitration and litigation, so the advantage of the mediation now will come, quick and effective resolution. Why I'm running little fast? Because we have got very limited time. So if anything you are missing, please, you can just interrupt me and ask the panel. So advantage of the mediation is it is quick and effective resolution. Unlike litigation, which can span over years, dispute can generally be resolved during the mediation in a matter of weeks maximum. So like in Hong Kong, parties are encouraged to attempt mediation, and the court can make an adverse cost order against the party who unreasonably fail to engage in the mediation. So in Hong Kong, this practice is very much in common. Cost effective, Cost involved in mediations are considerably lower when compared to the litigation or in arbitration. So the cost effective is divided into the parties. It is not by separate price has been asked. It is whatever the cost for the single mediation, that will be divided into the two parties. So you don't have to give the complete fees. One party doesn't have to bother for that. The confidentiality, unlike litigation, which may be open to public, mediation takes place in a private and confidential setting, where the mediators are not even allowed to take the pen and paper. If the mediators taking pen and paper with the permission of the parties, and once the party is out of the room, before the party goes out of the room, the mediator has to shred that paper where he has written even a single word. So preserve relationship in mediation. Both parties, they don't break the relations after mediation. There are chances that both party can be happy and again long living and togetherness and the happiness within them. So unlike the continuous nature of litigation or even arbitration, the forces of mediation is the facilitate and amicable statement. Little bit the disadvantage of mediation, where we think that it is non-binding nature. The voluntary non-binding nature of the process can result in the parties being non-committed unless and until the parties enter into the binding statement. So it is very important to start the mediation. Before mediation, mediators must take the consent signature from the parties that whatever the agreement will be there, it will be binding. Time and cost consuming. So consequently, where either party is not committed to settling the dispute, this is the disadvantage of mediation. Consequently, where either party to and they can just go for the litigation again, where there is no any fruit of that, any good outcome for that. So what is the first, what comes first, arbitration or mediation? So there is nothing compulsory that whether you should go for the arbitration or you go for the mediation. You can go for the arbitration first and then you can come for the mediation, or you can go for the mediation and then again go for the arbitration. Even in the middle of the case, arbitration or litigation or the court proceeding, if you want to go for the mediation, court will allow you to go for the mediation. So it's a good idea to agree to the arbitration or mediation in advance. Always it is better to be prepared for the mediation. And now the entire world is looking forward for any dispute first to go for the mediation. In high fast life, so much stressful life, nobody has got time to go for the court case and wait for dates and dates and spend so much money. People, they are all the disputes resolutions are first priority by the mediation. So this is how the mediation is there. So now let's come to the Radanks Limited's slideshow for the mediation. Sally, can you put the slide second page, next page? So you can see here in the picture, it has said that mediation is like a root canal where communication flows and all the bulk of confusions, misunderstandings pass through the funnel. So you can see that Lisa can little bit slide up. I can't see, no, last page.
I'm not sure she's able to do that, Dr. Raj. I think the bottom's got missed off.
Yeah, no problem. So this is just like in mediation, it is communication. Usually in litigation, you do the communication through the lawyer. Second party is there. Suppose you want to say, I took food and in my food, bread, butter and jam was there. But the arbitrator will say, the lawyer will say, the advocate will say, you don't have time to tell judge that you have eaten bread, butter, jam, and breakfast. So the arbitrator will make this small statement is this sentence. He will make, oh, they took the breakfast, because he has not explained that what was in the breakfast and that caused them the stomach upset or some other problem. Judge will not know unless the arbitrator will take the another date, another time, because the time is limited. And the client wants to say that because I ate bread and butter, that has made my stomach upset. But he can't or she can't. But in mediation, client is free to say everything, what exactly client want. And the conversation is very important. Sometimes misunderstanding creates a very big problem. Unless the misunderstanding is sorted out, you cannot sort your problem. So the mediation is the right process for the communication to get rid of your any dispute. Next slide, Lisa. So this we have already discussed with the upcoming popularity of mediation in the world of ADR, only logical to explore guidelines that can be set in place, business to follow. So this is the this already we have discussed that mediation, how it is becoming popular, and we are looking forward for entire world to bring it in the first step for any dispute. Next page, Lisa. So I don't have to discuss this, the pre-dispute stage we can see on the next slide. And it is compulsory to both the parties to get agree for this mediation. Unless if one party doesn't get agree and the other party is agreeing, mediation cannot take place. So for mediation, it is very compulsory both the party to get agree to go for the mediation, and for the one mediator, which is for the both the choice. Yes, next slide, Lisa. So these are the initiation of the mediations and how it is going on. So please circulate these slides to all our panelists and to whosoever are attending, because it will be very long for me to explain. So next slide. Yeah, go on. So appointing the mediator, this is very important. The appointing the mediator, it is not like this that A and B has got dispute and A want Radanks International and B want London School of Mediation, and they are just struggling for that. So it is very important to come to the point that A and B are agree to go with the Radanks mediators, and they will be happy to settle their dispute. So it is always compulsory to see that both the parties should agree for the one mediator, and then the mediation process will be there. And mediator must be accredited, well qualified mediator. Any lawyer cannot do mediation, any legal practitioner cannot do mediation. And that is, if any legal practitioner is doing mediation, it is null and void unless the lawyer is qualified mediator. Unless the legal practitioner is accredited mediator, his or her mediation services will null and void. So it is very compulsory to see the mediator is qualified or not. Yes, please go ahead. Yes, go ahead. So pre-mediation process also, you can just, I have already explained that. And yes, next phase. Yes, next, yeah. So mediation process takes in the confidentiality, it is in the closed room, and mediation in both the parties. If they are not happy to sit together, they will be a separate individual session together. And then once they are agreed to go for the joint session, they will go for the joint session. So the mediation is according to the client's choice and according to the client's willing that what exactly they want and what solution they want to do. Next page, Lisa. Once the mediation is over, mediation has gone successful or fail. It is not compulsory that all the mediation is 100% successful. So mediation can be fail also. And once the mediation is successful or fail, mediators, before the parties come out of the room, mediators have to make sure that both the parties have got signed paper consent to come to the conclusion. Sometime what happened, the parties come and they do the mediation, and at the time of final decision, they say, oh, I cannot take the decision, my brother will take the decision. So that makes the total mediation fail. So it is always compulsory to get the signature consent paper from both the parties that they are allowed to take the decision for the final decision of the mediators. If they say yes, then the mediation process is there. And the mediators, if they're leaving the room, if they have written any papers or any comments on the paper, it is very compulsory to show the client and shred the paper in front of them only. Next page. So this is all we have done for the mediation, how the mediation process are done and how the mediation and the arbitration is different from that. The mediation is any mediators, those who are qualified, accredited, they can do the practice. For becoming mediator, you don't have to be a law background. Any person can be, any professional can be mediator in their own way. And the mediators are always welcomed. Any question?
Thank you very much, Dr. Raj. So am I right in thinking you could get I'm getting a bit confused. So you say you can go to arbitration first and then mediation, but isn't it the other way around?
You can do, you can do first arbitration and then mediation, or you can do first mediation, then arbitration. Litigation is always open. Mitigation, this mediation is also open. Suppose you have gone with your case for the court case, complete long 2-year, 3-year cases you have done, and the court has given the decision. Here a court has awarded you decision that this is the decision, and you are not happy with that decision. You can go for after the court decision also. You can go for the mediation and get the resolution. And sometimes it happens that when the court has given some other decision, but the party, when they went for the mediation, they have got their choice decision and they are happy. And once the mediation is done, no one can challenge in anywhere that the mediation is wrong. No one can challenge, and no court can ask any mediator to come and explain that what happened in the mediation and what documents are there. It's only rarest in the rare case, only court can ask or summon the mediators to explain that how the mediation has gone. So no one can challenge the mediations and the mediators, and no one can ask the mediators to come in the court to prove that you have done mediation right or wrong.
Thank you very much indeed for that clarification. Thank you. Thank you. Our next speaker is Felicia. How do you pronounce your second name, Felicia?
Bierkarck.
Lovely. Thank you very much indeed. And you're going to be talking with us on, I'm looking, yes, your peace building agent. I think that's a most wonderful job description. I'm enjoying that. So yes, please elucidate more.
Well, thank you so much for having me here today, and welcome to everyone listening. So I'm a mediator, and also I work with emotional health. So developing emotional intelligence and developing, like, bringing attention to the importance of emotional health. So when we speak of peace building, and mediation is part, for example, of processes that enable peace building, just as much as litigation originally is there to regulate peace in society. So litigation is not there to cause fight, much the contrary, is a device that societies develop as a process to pacify society, not to enhance conflict. And what happened throughout like the litigation history is that especially I think by the end, last century was, I think, a very important century in terms of reviewing the purpose of the courts and reviewing the purpose of litigation, because from last century onward, the courts became accessible to anyone. Before it wasn't quite like that, and then it started becoming accessible to anyone, any citizen, to be able to challenge their dispute and try a resolution through the legal system. But what ended up happening is that the legal system became a tool for enhanced conflict. So the realities of, for example, going through a litigation these days is that you will enhance the controversy. So you would go one party adversarial to the other party, trying to see who is the last man standing, rather than building on to a resolution and looking forward to resolve the issue that's at hand. And then what I find really interesting is that when in the 1980s, 1990s, mediation started becoming something, a new format out of actually, it was very much the judiciary looking at things and saying, we can't go ahead like this. We are backlogged. We are like, conflicts are just enhanced rather than pacified through this process. So what can be there? How can we develop a system or a method that can help parties become enabled in communication so that they can build their resolution, a resolution to the problem that they know best what the problem is. And this is interesting because when we are in a dispute, the two parties or the parties involved in that dispute are the ones, the expert on that situation. They know best what the situation is. And if we would gather the informations or the resources of information that the parties have, we will be able to build a resolution that is suitable to that situation, much more than a judge looking from the outside, not necessarily able to understand the minimal dynamics of that situation, and will probably rule do a ruling that will not quite suit the situation, and then another process will start because someone would say no, it's not suitable, and so on and so forth. The litigations move on like a snowball. So like Dr. Raj brought out and Nick before me, this different, like this alternative dispute resolution methods were created in the aim to offer the public more than one lane. So you can go here or here or here as to what option is the most suitable to the situation at hand. And then for the majority of the cases, and this we see, for example, judges, like I was now I had the privilege to be in the courts during the summer, offering mediation to the parties coming to their hearing day. And many judges, they ask the parties, please go out and try a mediation because you will know best how to solve this. This is a process, like there's some things I can't rule here. Or the process how you entered with the process in litigation is not correct. So I cannot go on with this litigation in small claims, for example. You know, people start a litigation thinking they are doing the right thing. They come and then their process is not quite correct. So the judge can't go ahead with ruling anything and need to dismiss the case. And there they are, the parties still there, still in conflict, and nothing really resolved. So the interesting thing about mediation is that it will focus, is a contained environment that will work with the parties and focus on a solution and the moving ahead. Another interesting thing about the mediation is that it will enable the conversation to restart. So whereas in litigation, you will quiet down, you won't speak anymore, and someone will speak for you, your legal representative will speak for you. In mediation, you're encouraged to speak so that from your speaking and from your pouring out the information that you have in terms of what the problem is, the reasons of the problem can be identified, And then a constructive process can happen in building a solution for that. So instead of trying to find fault, right? So in litigation, you will try and find who is fault, who did that, and is investigative and all of that. In mediation is not, is a proactive process that will go like, okay, so we are here now. How do we build a solution from here? And then many people might say, well, there is no solution. You know, I don't have the solution. And yes, of course, if once we are stuck in a conflict, that's the feeling we have. Emotions play a great part in that. And usually they are the reasons why from a disagreement, a conflict or a dispute evolved. And but again, there is the true conversation and then a very focused conversation. Solutions can be identified and an agreement can be built. So like Dr. Raj mentioned, it's proven so much that most mediations, they can be resolved within a day of conversation, or even less, within hours of conversation. And by not talking, by not discussing it, sometimes we make things a lot bigger than they need to be. So what are the key elements for, if you are, say, if you are in a dispute, most people don't even know that mediation is there, or by just the word of mediation is interesting because people think first is like meditation. And it has nothing to do with meditation, but we are so unknowledgeable of what mediation is, right? Generally. So it's very, very important that the public informs themselves, you know, that we get informed of what mediation is and try out once. You know, try out is really not expensive and is not lengthy. So it's fast. And if you have a problem and a dispute, and mediation might or might not help you, but I tell you, it's like the amount of money you will invest in mediation, even if it doesn't come to a agreement, it's a money well spent, it's time well spent, because it will give you information and it will give you tools to move ahead. So the ingredients that make mediation work are the following, and this is why the process has been made like that, is because that is what makes the process work. So one of them is that the parties present at a mediation need to have the authority to settle. If they don't have the authority to settle, there is no point, because the negotiation will go through the process of brainstorming, of finding out what are the needs for that dispute to be resoluted, to be finalized. And only the parties who are really in authority to make decisions can actually find the way out. You can't, otherwise it doesn't work. So it's not about necessarily an option of willingness. It's just because if the party doesn't have authority, the negotiation can't go ahead. You cannot negotiate. And we all business people, we all know that. Unless authority to settle or authority to take decision is there, there's no great point in conversation. So authority to settle. The other thing which is important and is vital and is also one of the descriptions of mediation is that it is a voluntary process. And with that is two sides. One of them is that you have, as when you sign up for mediation and you say, you come with your partner and say, fine, I agree with that, I want to try mediation. You can stop the mediation at any point. So there is no need to follow through to go ahead. This is not quite like that with the litigation. It's sometimes a lot more complicated to back off. So when so in this mediation, you have the freedom to stop at any point. But again, the voluntary part of it is also that it's important that the parties are willing to find a way out, right? So the willingness of finding a way out is also a key ingredient. And sometimes the willingness to find a way out just comes because continuing that fight is so consuming of time, energy, and resources. So many people that engage in a dispute at some point throughout that process become just so fragile about emotionally, financially. I mean, and so it's sometimes people just come to the willingness of trying to resolve through that, through becoming really like to the point, okay, I can't go ahead anymore. But you can choose to do that much earlier, just because you can look positively and say, let's get through this and out. And it is very informal. So there is no formalities, as Dr. Raj was mentioning. There is no papers to be shown. There is no preparation in terms of proving your point. But there will be preparation and will be necessary for you to strategize and to understand what is your situation, what are your points that are important to you, and where are you willing to negotiate. So this is like such an important process in terms of finding out what is your situation altogether, and then finding out what are the measures or what are the alleyways that you can try the negotiation to go through. And it's extremely flexible. So you can book it and do it throughout one day, or you can have it spread out throughout a period of time, as flexible as these parties, this composition needs and wants to have it. So that is a brilliant part of it. And like Dr. Raj mentioned, confidentiality runs through and through in a mediation. So any information disclosed in mediation, disclosed to the mediator, is under confidentiality agreement. Also, any proposals done, any negotiation trials done within the mediation cannot be later taken and taken to, for example, to court and said, well, this is what it has been said then and then, because it is under the confidentiality agreement of the mediation. So with that, it's a very safe environment for this dialogue to happen. And well, I think the key takeaways is that mediation looks ahead. So it's not looking back and trying to find out reasons for whatever happened, but is looking at, okay, this is the situation, how are we moving ahead? It will identify the underlying causes and not the position, right? So it will explore the possibilities, preserving the individuals that are in their confidentiality. And then from that situation, one can negotiate a way out that is really suitable to the situation at hand. And many a time it happens that people go through the mediation and come out so much stronger at the other side, because it can happen that it re-enable parties and businesses to continue ongoing cooperation, rather than breaking through and having to deal with a lot of frustration that comes from litigation. So this was a very brief talk, and there is so much more to be spoken about in the front of what the benefits and how it can help us people and businesses in our everyday life. And I think, yeah, it's a good point to begin a long journey of conversations and education in mediation that's out there for all of us to use.
Thank you very much indeed. I think we are now, with these Zoom webinars, we are now learning the difference between mediation and meditation. So thank you so much indeed. Yeah, I'm aware of the time. Alan is going to have the final speaking slot, and Alan is going to be talking about how your chamber can actually help you. Alan, please.
Thank you. So I think it's a really good recommendation. Instead of any dispute, just take up meditation. That will solve everything. But if it doesn't, companies have contracts between each other, And in a lot of those contracts, and I suggest that if it doesn't, you have a clause in that contract that says arbitration. It will say on your contract applicable law, and it will say in there something about dispute. So I suggest that you have a clause in your contract that says arbitration. When I used to do a lot of big exporting for some very major companies, I've just looked up one of the clauses on one of the contracts that I signed a while ago with a major blue chip American manufacturer. And it was for their UK entity. And it said on there, Article 14, arbitration, all disputes, controversies, or differences that may arise between the parties out of or in relation to or in connection with this agreement or for breach thereof shall be entitled, shall be settled amicably through negotiations between parties. If such negotiations fail to yield an amicable result within 60 days, then such disputes, controversies, or differences shall be finally settled by arbitration in England. And it goes on to talk about what the law would be and where you could go. And I would suggest that you use a local chamber of commerce because our costs are lower. At the end of the day, you're going to mediation to end up with getting a satisfactory result to a dispute that you've got. And as Nick mentioned, when you go to court, you're in front of a judge and you simply don't know which way he's going to swing when he listens to the weight of evidence that's put at him. Through mediation, you're going to be talking and agreeing something between you, a mediator, and the person or the company you're in dispute with. So if you want to retain the way of resolving a dispute and keep it a lot more within your own control, then this is a very cost-effective, legally binding way of achieving that in a very fast manner instead of waiting years to get to, of which time equals money in most people's business. So we as a Chamber of Commerce are able to offer through the people that we work with a mediation and or arbitration service. We can offer that a cost-effective solution for people. You've heard the presenters who are the experts in this field. And if they don't resolve it, we'll let loose Sally on you. What have you got to say to that, Sally Smith? You're on mute.
I'm having mouse problems today. My hands are so cold working from home. I need to turn the heating on. No, as Alan and I had this discussion earlier, I am a marshmallow inside, so people will just walk all over me. So, you know, I am not, but yes, I am a talker. So yes, I do think, yes, the mediation is the way forward. So I'm aware
and
of
the most important thing and the very interesting thing is this, that mediator cannot be called as a witness to testify in any court case and cannot disclose any information related to the whatever the mediation proceedings are there. So this is one of the very beneficial and very much liked by the parties, because both the parties, companies, they are it is very confidential. So otherwise you get your case published in the paper, media, and the relatives, friends, everybody knows that, oh, you are going to the court case, judge has said this. In mediation, no way. It is within the room, inside the room, within you and the mediators. So it's one of the wonderful proceedings.
And you can sign a confidentiality agreement to that resolution as well.
Indeed. Yeah.
So there is legal consequences if it ever is divulged outside that room.
Yes. So this is the future, and welcome to the mediation.
Welcome to the future. Well said. Yes.
Excellent. Just to wrap up very quickly, all our webinars are on Zoom. They'll be on our, they're all recorded. They'll be on our YouTube channel probably by tomorrow. So please do look out for that. I do want to thank our speakers. Thank you so much for giving us your time this afternoon. Thank you. And yeah, please do read the emails that we send out on a virtual daily basis. All our events are publicized in the emails, and also
congratulations for the great achievement for the Chamber of Commerce. We have celebrated.
Thank you very much. Yes, yesterday we were awarded an award by Heathrow Airport for our services to helping them out. So yes, so thank you to Alan as for all his work he's doing on the Freeport.
And you too. Credit goes to Ellen, Sally, and Lisa. And we are so proud of you.
Oh,
excellent. Yeah, I'm looking forward for the party for us.
Well, we're working on that. Okay, thank you very much indeed, everybody.
Bye. Lovely to see you, Felicia. Bye.
Hey, have a great afternoon.
Bye, thank you.
And may all your legal disputes be little ones and resolved.
Indeed.
Thank you.
Well,
thank you.
take
Bye-bye.
care. Bye.
Thanks, everybody. Bye-bye.